It's time for us to start, and we've also formed a quorum. Item 1 on the agenda, confirmation of minutes. The minutes have already been distributed, and we've not received any proposal for amendment. Any comments? If not, can we have the minutes confirmed? So if there's no comment, the minutes are confirmed. We can proceed to item 2 on the agenda. Please invite the government representatives and the deputations to come in. Welcome. Please invite the deputations to come in as well. We welcome the deputations to this meeting of the Bills Committee to express their views. We'd also like to welcome the government representatives. In attendance today, we have from the administration, Ms. Jenny Chan, Principal Assistant Secretary for Transport from the Transport and Housing Bureau, Mr. S.F. Wong, General Manager for Shipping Registry and Seafarers, Mr. Y.M. Chang from the Marine Department, Ms. Mabel Chang from the Department of Justice, and Ms. Carmen Chan from the Department of Justice, as well as Mr. Jason Lam from the Transport and Housing Bureau. Today we are to listen to the deputations in relation to their views on Merchant Shipping Seafarers Amendment Bill 2013. Here I'd like to remind the deputations that their verbal remarks and written submissions will not be protected by the Electoral Powers and Privileges Ordinance. In a moment you can use your microphone. So you can clip the microphone to your lapel. You can also use your earpieces. Channel 0 is floor. Channel 1 is Cantonese. Channel 2 is English. Today, the speaking time for each deputation will be 5 minutes. First, Mr. Lee Kwok-kin from the Hong Kong and Kowloon Trades Union Council. Mr. Chairman, good afternoon. I'm the representative of the Hong Kong and Kowloon Trades Union Council. Under our council, we have a number of trade unions belonging to different sectors of the community. So here I'd like to report our views to you. There are about a couple of them. First of all, in relation to collective bargaining, on the 3rd of April, the Transport and Housing Bureau submitted a electrical brief to you concerning the part on public consultation on Seafarers Association's views. I'd like to offer some comments. I participated in several consultation meetings organized by the Marine Department. We support the proposed amendments with several conditions. First, for Seafarers Associations and Shipowners Associations, for collective bargaining, our views have not been accepted by the Consultative Committee. I also represented our council on those occasions. The draft report does not mention that point. Is unacceptable. Therefore, on behalf of the members of our council, I have to say that we cannot endorse that amendment. In fact, many seafarers' contracts have covered collective bargaining, and Section 3 of the IL, the Marine Convention, for basic principles, for the International Convention, the Marine Labor Convention, certain basic rights have to be respected. Right of association and right to collective bargaining. So for this part, we propose an additional provision to encourage shipowners or shipping companies to promote a voluntary negotiation mechanism together with the seafarers associations. As to who seafarers are, Section 2A is proposed to be added to the ordinance. The new definition is that any post on the ship except those in Schedule 1A will be included. Some shipowners have recruited cadets. They are trainees. According to that definition, cadets are also seafarers. However, for these cadets, that is trainees employed by the shipowners, their salary is only $100 to $200. So it's unequal pay for equal work. To encourage more young people to join the profession and to nurture more talents, that level of pay is counterproductive. So we propose to add another provision to encourage registered vessels to employ Hong Kong's young persons as cadets, that is trainees. At the same time, the minimum wage should be introduced to protect the cadets' salaries. To implement the minimum wage on seafarers, actually, the mainland and Taiwan have already got their own maritime laws to safeguard a minimum wage. The last point I'd like to raise is in relation to Section 6, in relation to the Consultative Committee. We suggest that originally there are 11 provisions. We propose another one. That is, meetings should be convened no less than once every 3 months. I've been with the Consultative Committee for quite some time. Apart from the consultation exercise on the Maritime Labour Convention 2006, we seldom had meetings. So we would like to have this platform for communication. 2 infrequent meetings won't suffice. So we would like to propose another provision, that is, to make sure the meetings are convened no less than once every 3 months. Next, Mr. Lee Chi-wai, Hong Kong Seamen's Union. I've not much to say. I'll hand over the floor to Mr. YANG Kaiqiang. Mr. YANG Kaiqiang. Concerning register and records, registration records, an ID card as a permanent resident must be held by a registered seafarer. What about the non-permanent residents? At the moment, some Hong Kong residents would like to join the profession but may be restricted by this provision. They won't be able to register. What can they do? Another point is about sick leave and industrial injuries. If a seafarer falls ill, how many days of sick leave can he enjoy? What about compensation? Point number 3. For the employment contracts, seafarers and shipowners can prematurely terminate their contract. This can come under consultation, but notice has to be given no less than 7 days in advance. In fact, Section 11 already stipulates that for any reason, if the contract is to be prematurely terminated, there should be 2 months of wages in lieu. That is as compensation. So I'd like to have some explanation from the Marine Department. Next, Mr. Kwok-kin from Orient Overseas Container Line Limited. Mr. Chairman, I have nothing to say for the moment. Next, from Merchant Navy Officers Guild, Hong Kong, Mr. Yu Chi-ming. I have nothing to say. Next, UNIVAN Ship Management Limited. Mr. John Jijiman Kalambatu. Next, Fleet Management Limited. Captain. Next, the Hong Kong Shipowners Association, Mr. Arthur Bowring.
Honourable delegates, good afternoon. We have submitted a written submission to this committee, and I will go through that very quickly just to explain where we are at the association. My association has been involved in the negotiation of the convention from the start, when the Joint Maritime Commission, which is a bipartite commission of the ILO, proposed that the maritime instruments be consolidated into one instrument. I was a member of the high-level tripartite working group and have attended the various conferences as a member of the China delegation. I am now the chairman and spokesperson for the Maritime Employers Group in the ILO, and I work very closely with the China delegation when attending the ILO. My association, therefore, has a great interest in this convention and in the convention coming into force. We strongly support the passage of the bill because it is important to our mind that Hong Kong takes a leading part in this convention. The other reason is that Article 5 of the convention has a no more favourable treatment stipulation, under which ships which are registered in countries that have not ratified the convention can be subject to a full inspection when they visit the ports of countries that have ratified the convention. It is the certificate, the Maritime Labour Certificate and the document Maritime Labour Compliance, which are taken as prima facie evidence that the ship has been inspected by the flag state and meets the requirements of the convention. And that prima facie evidence is then used by the port state inspectors when they go on board the ship to make sure that the ship complies with the requirements of the Convention. I think we have to realize that the Convention has been produced to protect seafarers' rights. It also protects the interests of ship owners in producing a level playing field so that ship owners cannot compete on the basis of lower standards for seafarers. This is why we support the Convention, and we think the Convention is a major step forward. I do have comments perhaps on some of the Union comments, but what I'd like to do is just to reiterate the fact that the administration has been through quite a few consultative meetings, tripartite consultative meetings, with the unions and ship owners in order to satisfy their obligations under the Convention, where certain parts of the Convention may be decided by the administration after consultation or in consultation with the relevant shipowner and seafarer organizations. That has been done, and we have been through that process. And that consultation has taken place in a way that, personally, I'm satisfied with. We had some very difficult discussions, but we came up with a consultation which meets the requirements of the Convention. I think we also have to realize that the Convention itself was adopted by the ILO unanimously. Every tripartite delegation in the ILO agreed and adopted the Convention. There were 4 abstentions because the tripartite representation was not present from those particular states. This is a convention which has widespread appeal, widespread acceptability, and it will have widespread ratification. It is important that Hong Kong has the legislation in place as soon as possible so that when China says to Hong Kong, we are ready to ratify, are you ready? We can say, yes, we are ready, and we will join with you in the ratification. Thank you, Chairman.
Anglo-Eastern Ship Management Limited. Captain Rick Ran Mohotra.
Yeah. Good afternoon, Mr. Chairman and delegates. Further to what Mr. Bowring said, and in complete agreement, we also fully support the bill and look forward to the legislation being in place as soon as possible, with the deadline looming very shortly. And we, as a company, completely support the Maritime Labour Convention. No more comments. Thank you.
We still have some time. Any other deputations would like to add to that? If not, is it the case that, well, for the administration, they would like to respond to questions raised before we ask members to ask questions? Thank you. First of all, I thank deputations for attending. The majority of them support the implementation of the MLC, the Maritime Labour Convention. Mr. Lee mentioned about collective bargaining. The provisions of the MLC requires signatories to respect the right of collective bargaining, but there is no requirement to legislate for it. So this time it's not incorporated without contravening the convention. Collective bargaining is still under discussion in Hong Kong. It's rather controversial. Mr. Matthew Jiang, the Secretary for Labour and Welfare, responded to questions in the LegCo on collective bargaining. This doesn't just involve the maritime, it involves all different sectors. So it's inappropriate to have a discussion here, because the objective of the bill is to is to meet the requirements of the MLC. Mr. Jiang, the Secretary, said in his answer to legislative questions that the administration will, through encouragement for the different sides to have a discussion, all forms of negotiation will have to be done on their own accord and initiatives. The rules should not be laid down to make for the negotiation. They should be formed among the two parties with rigid rules set down. It may only antagonize and it won't be conducive to negotiation. This is still under discussion. We have yet to forge a consensus on collective bargaining. In relation to the advisory committee, Mr. Lee proposed that meetings should be convened no longer than once every 3 months. Well, we have to give them flexibility, and it should not be rigidly set as to the time when a meeting is conducted. We'll liaise with the Marine Department to see if we can increase the frequency of the meeting to exchange views with the sector. I think the Marine Department will follow it up. In relation to other questions, I will defer to Mr. Wong. Mr. Wong? In response to Mr. Lee's second question, that is, who are seafarers? Mr. Lee mentioned about cadets. In our proposal, cadets are seafarers. We've never said that cadets are not seafarers. And in relation to the minimum wage, Mr. Lee mentioned that it may be as low as 100 to 200 US dollars. Well, we have looked at seafarers' employment agreements for cadets, for local seafarers who are cadets. The wage is not as low as that. And I believe most of you will know that when it comes to seafarers' remuneration, the administration gives a subsidy of $5,000 a month. And in relation to whether the minimum wage should be incorporated into the bill, well, the impact is not just about Hong Kong cadets. This amendment bill applies to seafarers working on board of a Hong Kong vessel, regardless of their nationality. And as to whether we should set the minimum wage of seafarers, I don't know whether it's just about cadets. We think that at this stage we can't really decide about the way forward. If under different committees, say for example under the advisory committee, if seafarers have a view to express, they can ask for a discussion on this issue. And that is in relation to Mr. Lee's 3 questions. P.S. Can I continue to say something in response to Mr. Yang? Yes. Mr. YANG Kaiqiang talked about, well, under the legislation, if you are to register as a seafarer, you need to be a holder of you need to be a permanent resident of Hong Kong. Mr. Yang said that if it's a Hong Kong resident, then is that all right? Because we want to encourage our youngsters to take up a career in this regard. The sector has been doing very well to encourage the younger generation to pursue a career in this line of work. within Hong Kong, they can apply for any jobs and take up any employment. I'm not an immigration officer of the Immigration Department, but as far as I understand, there is no restriction on employment. But when it comes to registration of seafarer, the nature of the work, say for example for ocean-going vessels, the person will not be just working in Hong Kong. I don't know whether this word should be used, but it's whether the word travel should be used, but the place of work can be beyond Hong Kong. So other policy bureau may be involved. And we need to discuss with other policy bureaus as to whether we can relax the restriction to register to get the red book and engage in work that is outside of Hong Kong. And we will look into that. Mr. Yang also mentioned about compensation, say for example sick leave. I will defer to Mr. Chang. Mr. Chang? In response to Mr. Yang's question about new requirements under the bill when it comes to sick leave, this is an administrative guideline. The new requirements will be incorporated in the subsidiary legislation requiring ship owners to fulfill this responsibility. Let me give you some background information. Under MLC, ship owners have the responsibility to pay for medical expenditure, full salary, and provide for food. Anything to add? Perhaps let me add something. If I understand Mr. Yang correctly, he was referring to someone working on shore. When it comes to sick leave, under the MLC, the new MLC, there is a requirement that when a seafarer falls ill or is injured and cannot work, as long as that person is on board the vessel, the employer has the responsibility to pay him full salary. After leaving the vessel, say for example, the person may have to seek medical attention in a hospital, or the person will have to rest on land, or arrangements will have to be made to send the person back to his hometown. The employer has a responsibility to pay at least a quarter of the salary. So it's not the case that ship owners can wash their hands when a seafarer falls ill on board of the vessel. Under the convention, there is certain responsibility to be borne by the ship owner, so there is protection. Chairman, you have any question? No. But I'd like to see if other members have any questions to ask. Perhaps I will add one point to respond to Mr. Yang's third question.
Mr. Yang's third question is like this. According to Section 91 of the existing ordinance, if a seafarer has his contract prematurely terminated by the employer, there will be a 2 months compensation. According to the convention, a 7-day notice at least should be given under the amendment bill. Mr. Yang's observation is correct. Section 91 does have that compensation provision. That is 2 months compensation. That section also spells out the circumstances concerned. Take, for example, an accident occurs to a ship is damaged. Well, a ship owner won't want to see that. So it has nothing to do with the conduct or discipline of the seafarer. But the ship owner has to prematurely terminate the contract. Say, for example, a vessel is to be sold, then seafarers may have to be dismissed. Or if a vessel originally flying the Hong Kong flag no longer flies the Hong Kong flag, then contracts may have to be prematurely terminated. Then from day one of the incident, that is the occurrence, the ship owner has to pay the seafarers concerned for 2 months. As for requirements to be satisfied for termination, there are separate provisions. For example, today, between the seafarer and me, there is an agreement. I may have to give the other party a month's notice. Under the convention, there's no requirement on whether or not there should be a 1-month notice or 2 months notice, but a 7-day notice has to be given. According to the 2006 convention, it does not mean that the 7-day notice is a strict must. In fact, for most employment contracts, the mutual notice required is 2 months. Even for the shortest one, it has to be at least a month. If suddenly an employer has to terminate the employment of the employee, a 2 months compensation has to be paid. So between the two requirements, there's no conflict. I hope that I have explained this clearly to Mr. Yang. Members, any questions? Any questions on the deputation's remarks and the administration's response? Mr. Tan Ka-piu. Thank you, Mr. Chairman. I'd like the administration to provide more information on some of the deputation's remarks. I come from the labor sector. Therefore, I, of course, want to see legislation on collective bargaining. In this particular industry, there is an established negotiation mechanism. So why can't we just implement the convention in that regard? What are the considerations of the government? And Mr. Lee from the deputations asked whether the administration had any discussion on legislation. If the decision is still not to legislate, after the enactment of this amendment bill, will the government continue to conduct discussions? Besides, some deputations already mentioned that very few people are now joining the profession. The new recruits are mainly new immigrants from the mainland. It's difficult for them to go back to the mainland. At the same time, they are not yet qualified for applying to become seafarers. Will the government conduct some discussions in that regard to meet the needs of these categories of persons? Thank you, Mr. Tang, for your questions. For collective bargaining, previously, tripartite meetings were convened among the government, the ship owners, and the seafarers, and this topic was covered. In fact, employers and employees have different views on this, and the convention does not require legislation. Therefore, this amendment bill has not covered this. As for discussion on the right to collective bargaining, we have to do it in the general sense. Other professions, not just the shipping industry, are also concerned about this. I believe the Labour and Welfare Bureau will have its own viewpoints, and wherein necessary, we can follow up. This time, we'd like to implement the convention as soon as possible. There are other requirements in the convention that provide much better protection to seafarers. So we'd like to have consensus and to implement the requirements under the convention. As for other controversial issues, we cannot cover them in this exercise. As for the requirement for a Hong Kong ID card, we can continue to discuss that. There's no express provision in the convention. If we decide to legislate, we can discuss further with the trade associations as well as the associations concerned. Mr. Tan Kaiqiang, I heard that you're willing to continue to discuss those two issues. We, of course, welcome that. But it seems that she is implying that if the Secretary for Labour and Welfare has not decided to consider collective bargaining, the administration will not contemplate legislation. Can you clarify that? That is, you need the green light from Mr. Matthew Cheung, the Secretary for Labour and Welfare. If the issue is already mature, why can't you start discussion now? Because there are requirements in the convention. The convention only requires that right to be respected. It's not a mandatory requirement. And throughout the world, throughout all the signatories, there's not shared consensus among parties concerned. Of course, this is a labor issue, so we have to hand that over to the LWB for a comprehensive observation. Any follow-up comments? Mr. Poon Siu Ping? Sorry, the speaker is not coming through. Mr. Chairman, I'd like to thank the deputations for coming to air their views. I heard that most of them were in support of the early implementation of the convention in Hong Kong. Mr. Lee Kwok-kin asked about the definition for seafarers and asked whether it covered cadets, the trainees. It's explained that through the statutory minimum wage committee that can be followed up. If the pay is too low, new recruits won't find that attractive. In answering Mr. Tan Kaiqiang's questions, you said that the Labour and Welfare Bureau will be responsible for any follow-up. How long will it take before the implementation of the convention? Can you do something to satisfy some of the requests of the deputations just now? Do you have any time frame? Ms. Chan? Studies will take time and will involve a number of government departments. We also need tripartite meetings among the government, the shipowners, and the seafarers. In fact, this amendment bill is to implement the convention. We hope that the amendment bill can be enacted first, and then we can introduce subsidiary legislation to implement the convention comprehensively. And after this exercise, if we find further changes necessary, we'll introduce amendments. But this exercise targets the implementation of the convention. We would like to handle that first. No more follow-up? Members, any more questions? Mr. Tan Kaiqiang? Mr. Chairman, can I ask something that is not really related to the remarks of the deputations just now? Well, you can ask your questions first and see whether the administration is ready to answer. Well, of course, it's related to the bill as well. I'd like to clarify. I have issued a letter, paper 1252-01. There are 8 issues. Well, Mr. Tang, in relation to your letter, will ask the administration in a moment to provide a comprehensive reply. For this part, that is part 1, we should focus on the deputation's views. If members don't have any further questions, I'll see whether there's any follow-up from the deputations. Mr. Lee Chi-wai and then Mr. Lee Kwok-kin. I think I have to set a time limit, 4 minutes for both questions and answers per deputation. I'd like to ask about sick leave. At present, as far as I can see from the laws, nothing is mentioned about death resulting from illness. If a seafarer dies as a result of illness on a vessel, should that be treated as industrial injury? I've handled a few such cases. In the collective agreement, it is stipulated that so long as the death occurs on the vessel, then the provisions will apply. But what if a seafarer contracts a disease on board a vessel but dies at home eventually? Who will answer this? Mr. Chang. Thank you, Captain Lee. In future, funeral expenses to be borne by shipowners will be spelled out. If a seafarer dies on board a vessel, how should compensation be paid? Under the convention, there's no direct provision. In the contract between seafarers and shipowners, only funeral expenses and the property of the seafarer concerned are mentioned. As you have raised this, I'll go back and consider whether or not in future our laws should have further provisions in that regard. Any follow-up? What I want to say is that on the mainland, if a seafarer dies on board, that should be treated as industrial injury. But the definition of industrial injury can easily be found in Cap 282. But there's no clear definition for death on board. So compensation may be problematic in future. You are now legislating on this amendment bill. I wonder whether you can add something to the present amendment bill. In future, there may be arguments. If a seafarer contracts a disease on board but dies at home, the shipowner may say that, oh, the seafarer does not die on board, he dies at home. So it's very unfair to a seafarer. If a seafarer contracts a disease on board, he goes home and consults doctors, but he dies at home. Then the shipowner will say, oh, he doesn't die on board, he dies at home. Then what should happen? Perhaps I should try to answer Captain Lee's question. Well, let's set aside the convention for a moment. According to the standard agreement, it's only stipulated that a shipowner has a certain obligation. If a seafarer suffers from industrial injury on board or has died, the details of compensation are not spelled out. But if a seafarer unfortunately dies on board, the shipowner is responsible for the funeral expenses, repatriation of the remains, etc., etc., back to the place of origin. As Captain Lee said, a seafarer may contract a serious disease on board, but later dies at home. So how should the disease be traced? Has the disease aggravated and lead to his death? I have to say that the convention does not define under what conditions deaths would be compensated.
And this we'll say that we have to further look into. Ms. Chan. I thank Captain Lee for raising this issue. I believe that this involves the subsidiary legislation. This is a bill. We're drafting the sub-legislations. We will look into this issue when we're drafting the subsidiary legislation to see if we need to provide for that. Thank you. Mr. Lee Kwok-kin, in relation to Ms. Chan's response to us in relation to collective bargaining, I find that unsatisfactory. She said it's controversial. Well, because this is ratified in Hong Kong. This is Article 98 of the ILO. Why would she still say that it's controversial? As far as I understand, the administration's stance is to encourage the labor and the employee and the employer to negotiate. But this is not mentioned at all. So this runs counter to Article 98 of the ILO, that is, to promote the development of collective bargaining. So we ask the administration to consider it afresh. It's not the case that no governments have, according to the MLC 2006 legislate for collective bargaining. On the mainland, there is already one for seafarers collective bargaining. This is the first collective bargaining agreement among the different trades. So this is not the first in the world. If we don't have this provided in the agreement, we find this regrettable. And then the general manager talks about the subsidy of $5,000. Yes, we know the reason why there is a subsidy. If the wage is not so low, then there is no need for this subsidy. And $5,000 is not something that comes handy to everyone. We only have about 70 or 80 seafarers. If it's not attractive enough, then no youngsters will join the trade. How come the China and Taiwan can do it, but we can't? If the Marine Department looks at the seafarers' employment agreement, you see that our work is tough. Then why can't we enjoy a decent wage? I asked the administration to give me some concrete response in relation to these 2 points. Who is to answer? Mr. Wong? Thank you. Perhaps I will first answer Mr. Lee's 2 questions. First, collective bargaining. Mr. Lee correctly pointed out that Hong Kong, well, Article 98 of the ILO in relation to collective bargaining applies to Hong Kong. If you are familiar with the requirements of this article, it's not the case that if it applies, then you have to legislate for it. The article itself requires signatories. If they are to adopt this article, promote the development of collective bargaining. In other words, Hong Kong or the Hong Kong government or the Marine Department in particular, when it comes to the seafarers sector, the seafarer art unit is not will find It's unacceptable if you incorporate collective bargaining in an agreement. We've always abide by the spirit of Article 98 of the ILO. We respect agreements to be done by collective bargaining. We encourage it, and this is our direction. When we vet the content of the agreement, we consider the agreement given the light of collective bargaining. May I continue? Minimum wage. Mr. Lee also mentioned about $5,000. The objective of the subsidy, of course, is to help the cadets and to encourage them to make cadets think that seafarers can be a lifetime career. The $5,000 is to encourage them. It's not because their wage is too low, and this given as a top-up. If the trade is not appealing, then even if the administration gives $5,000, youngsters will still be reluctant to join. Yes?
Come in very quickly on a few of these issues, if I may. First of all, collective bargaining agreement, just to support the administration here. Article 2 of the Convention does say that the state has to satisfy itself that certain ILO fundamental rights that the provisions of its law and regulations respect in the context of the Convention these fundamental rights. There is no requirement in the Convention for the negotiation of collective bargaining agreements. Under the Seafarers Employment Agreements, which is Regulation 2.1, the seafarer is given a chance to negotiate, to have legal advice, seek legal advice on the Seafarer Employment Agreement. The Seafarer Employment Agreement may include the provisions of a collective bargaining agreement, but it does not have to. I think it's very important just to point out those issues. On the question of cadets, our association, together with the MPPF, have been recruiting cadets for the last 10, 11 years, and we have been successful in attracting youngsters, Hong Kong youngsters, to join the seafaring career. I think we've put about 150 cadets through the system now. We have our first Class 1s, which is Master Chief Engineer rank, which are already adding to the maritime capability of Hong Kong in quite a major way. Joining the Marine Department, joining the Pilots Association, and staying at sea, staying in the maritime industry. I'd also like to point out that on the continuous consultation, there are requirements in the Convention for continuous consultation with the tripartite bodies, with the seafarers and shipowners organizations, with the administration. Also within the ILO, we have a special tripartite committee, and the first meeting can only be held after the entry into force of the Convention, and it will be held in April next year. I understand that I will be chairing the employers group at that meeting. And that committee is there to assess the ongoing work of the Convention and to propose amendments, if amendments are needed, to the Convention, if it's found the Convention doesn't work the way that it's intended to. As I say, that committee will be meeting on a very regular basis in Geneva to look at the Convention and to propose amendments. And there are amendments already in hand to the Convention that we will be discussing in April next year. I think that's really all I need to do to answer the few questions that have been raised. But just to say that this Convention is a major step forward for seafarer rights, and it's very important that we legislate as soon as possible. Thank you, Chairman.
Thank you.
I think Mr. Bowring made some suggestions or some comments. Administration, anything to add? Sorry, I'd like to add one point. In response to what Mr. Lee said, Lee Kwok-kin said, cadets. Their wages are too low, he said. In relation to collective bargaining for seafarers, associations and shipowners every year, in relation to every grade of seafarers, they reach a consensus about the wage level. As far as I know, for 2013, 1st of January, the shipowners associations and seafarers organizations, in relation to cadets' wage levels, agree that the minimum level is $239. Coupled with the overtime payment, a cadet can earn $448. This is an acceptable level to ship owners associations and seafarers organizations. Time's almost up. I'll let Mr. Lee ask a short question. Thank you. Mr. Bowring actually in 2007 attended a tripartite working group meeting with us. He clearly pointed out the stance of shipowners associations. Let me quote minutes of 2007 minimum wage. Mr. Bowring said,
under the requirements of MLC guideline B 2.2.3 paragraph 1, the government should establish procedures to determine minimum wages for seafarers. 其實呢一個呢，勞資雙方都有共識嘅。
So there is consensus between the employers and the employees. What is lacking is whether minimum wage will be introduced for seafarers. Administration, any short reply? I believe the Marine Department has already touched on minimum wage. This is not a requirement of the MLC. If the trade would like to discuss it, there are some channels, say for example the advisory committee, for detailed discussion. Mr. Bowring would like to respond. To be fair, I'll give him some time to respond. And then this session will come to an end. Mr. Bowring?
I don't need very long, Chairman. Thank you very much. Maybe just to point out that B, Code Part B, are guidelines. And the word should is used very clearly in these guidelines. And it says, without prejudice to the principle of free collective bargaining, each member should, after consulting representative shipowner and seafarers organizations, establish procedures for determining minimum wages for seafarers. It doesn't say that they have to. This is a recommendatory guideline. It is there as a guideline and is there for the tripartite consultation to discuss whether procedures should be put in place for a minimum wage. It's not a requirement that a minimum wage is established. Thank you, Chairman.
Oh, thank you.
Thank you. Administration, no reply? This part is finished. If you can leave me your submission, please sign them and then hand your submissions to us. And if you still have some more comments to make, you're most welcome to do so by writing to us. Thank you very much for attending this public hearing. Thank you. You may leave now.
The
next part will be meeting with the administration. At our first meeting, a number of members of raised doubts about the amendment bill. The administration promised to come back with answers. So I'd like to see if the administration has any response today. Mr. Chairman, our response has already been set out in paper 1213/03. Perhaps I should briefly explain the paper to members. Yes, we mainly respond to two issues raised by members. First is whether the Maritime Labour Convention will be fully implemented in Hong Kong by way of legislation. Our answer is in the affirmative. In this exercise, we're mainly amending definitions. There are 14 areas with specific MLC requirements. After the enactment of this amendment bill, we'll introduce subsidiary legislation to the LegCo detailing the 14 areas. This time, we're explaining the content of the convention and why it should be implemented. The details are set out in the annex to the paper. Minimum age, physical check certificates, and employment agreements. The development and management of private and public organizations, rest time for seafarers, standard of seafarers and vessels, the requirements of the living rooms, etc., the entertainment rooms, meals, safety and occurrence, medical facilities and services, complaints, and payment of wages. Now, according to the convention, all these have to be implemented by way of legislation, and all these are set out in the amendment bill. And so, a new piece of subsidiary legislation will be introduced, and 10 subsidiary legislation will be amended. This is an MLC requirement, and it's already spelled out which requirements have to be introduced by way of legislation. We've consulted the DOJ, the shipowners, and the seafarers. And all those requiring local legislation are covered by this amendment bill, as well as in the future subsidiary legislation to be introduced. The second concern of members of the last meeting is about the direct reference approach. In the principal ordinance, there's an empowering provision in relation to direct reference approach to subsidiary legislation. Not every international requirement is suitable for direct reference approach in local legislation. When considering whether or not to adopt the direct reference approach, we have a number of considerations. All these are set out in numbers 1 to 5 of the paper. Concerning specific conventions, requirements, we have to see whether they're specific and whether they're easy for perusal, and then whether or not specific the first consideration is whether the requirements are clear and specific enough. The second consideration is whether the agreement provisions are easily accessible and read. The third is whether the agreement topics concern specific group of people and whether such people are familiar with the requirements. And number 4, whether such requirements are applicable to all party states and conducive to uniformity, and whether the terminology is compatible with local legislation. If all these requirements are met, we'll use the direct reference approach. And this will not inconvenience shipowners or seafarers, because they have to keep copies of these requirements and they have to be familiar with the requirements, because vessels do go from one port to another, and these requirements are applicable under the convention. At the moment, we have a number of shipping laws that adopt the direct reference approach. That is CAP 369, Merchant Shipping Safety Ordinance, and Merchant Shipping Prevention and Control of Pollution Ordinance, CAP 413. All these are set out in Annex 3 of the paper. As for other jurisdictions like Australia, Canada, and New Zealand, they've also adopted the direct reference approach. The examples are set out in Annex 4 of the paper. We consider the proposal for subsidiary legislation and consider direct reference approach suitable for the specifications of crew accommodation under the MLC. That's in Annex 5, because the size of the bed, heat insulation requirements, etc., are set out. So that it is very important to have standardized requirements when vessels go to different ports and different jurisdictions of the world. The subsidiary legislation will have to be submitted to the LegCo for scrutiny. This is only an empowering bill. In the course of negative vetting, members will have an opportunity to go through the subsidiary legislation. Mr. Tan Ka-piu submitted a letter in the hope that the administration will consider certain views of the industry. The administration has not provided a written reply yet. Is there any verbal response now? And you can further follow up if members have further questions. Concerning Mr. Tang's letter, a number of issues are raised. I'll follow his sequence. First of all, about medical facilities on board. According to the convention, a vessel holding 100 persons or above and plying internationally for 3 days or above, them should be a doctor. In fact, passengers are also covered. And we're talking about passenger vessels, because freight vessels won't have 100 persons on board. And the regulation does have a similar stipulation. That is, a vessel holding 100 persons or above will need a doctor. At the moment, there's no specification on the 3-day requirement. Under the MLC and after discussion between the shipowners and the seafarers, as resources are sufficient, this 3-day requirement is reasonable, so we'll adopt the convention standard. This will not appear in this amendment bill, but will appear in future subsidiary legislation amendments. The second issue is medical certificates. We'll refer to the 1978 International Convention in relation to fitness certificates. At the moment, the requirements are set out in CAP 4780 in the schedule, and the schedule will be amended. The certificate requirements are similar to those at present. We have to protect the seafarer. A seafarer has to be fit before he should work on board. That is to protect the seafarer. As for working and rest time, perhaps a seafarer may not regularly work 8 hours a day on board because of repair work or when a vessel berths at a port. A seafarer may have to work more than 8 hours. So 8 hours is just a standard. Exceeding that will be considered overtime. In the amendments to subsidiary legislation, overtime work will be allowed. After tripartite meetings, we came to the opinion that we should legislate for a minimum rest time. That is, for any 24 hours, the rest time must not be less than 10 hours. And for every 7 days, no more than 77 hours of work. This has already been agreed. And then for qualifications for seafarers, for persons not satisfying this 7-year residency requirement, will pursue the matter further. And for seafarers' employment agreement, Section 91 of the ordinance stipulates that because of special circumstances like ship damage or reasons not because of the misconduct of the seafarer concerned, and the agreement is prematurely terminated with no arrangement of other work from the ship owner, then the seafarer will be entitled to 2 months' compensation. That will be maintained. Under the convention, will stipulate the shortest notice to be 7 days. As Mr. Wong Sai-Fat pointed out, that's the minimum requirement. Under the agreement, a longer notice period is all right. Number 6, complaints procedure on board. Under the MLC, a seafarer is entitled to complain to the master on any issue or complain directly to the Marine Department. This is to protect the rights of the seafarer. Of course, if the Marine Department receives a complaint, it will consider whether the incident is against the law. After investigation, if it is discovered that a ship owner acts against the law, prosecution may be taken out. If the incident is not related to statutory requirements, we'll try to promote communication between the ship owner and the seafarer concerned, and will safeguard the interest of seafarers. Number 7 is about Hong Kong Macau vessels and river vessels. The ordinance is mainly related to ocean-going vessels with journeys very often more than a month, and seafarers have to work and live on board. The scale of operation, the modus operandi, etc., are very special for ocean-going vessels. So we need international standards to regulate internationally plying vessels. Such requirements may not be applicable and suitable for cross-boundary vessels, the seafarers of which will go home to rest after working. So the convention will only be implemented for international vessels. As for cross-boundary passenger vessels, in relation to employment of seafarers, sea employment contract, etc., there are also certain requirements. As we pointed out last time, on the issuance of operation certificates, the Marine Department will stipulate that there must be 1 rest day for every 5 days of work. These are similar to the MLC provisions. As for entertainment vessels, for those leaving Hong Kong waters, there are also international voyages, so we'll adopt the definitions under the convention. So much for my response. 2 members have asked to speak. First, Mr. Alan Leong, and then Mr. Tan Ka-Piu. Mr. Alan Leong, thank you, Chairman. I'd like the PAS to clarify one point. She said that the amendment bill is only an enabling piece of legislation. In future, under the convention, there may be various requirements, and negative vetting will be adopted for introducing those subsidiary legislation to the LegCo. How will those arrangements be? Now, this blue bill is so thick. With so many amendments, it's only an enabling legislation for Annex 5, for the living rooms and entertainment facilities. Can you cite some examples under Article 3.1 of the Convention so that we can see how the Blue Bill can be an enabling legislation? And then in future, what legislative process you'll adopt for things like living rooms for seafarers on board?
There are two parts. First, amendments on definitions, say for example, seafarers and permitted organizations. There may be the same amendments in different provisions. There are also enabling provisions to adopt the direct reference approach. And in relation to the accommodation, well, we are working on the subsidiary legislations, a new one, stipulating that ocean-going vessels will have to obtain a permit. And as to how the permit is obtained, they will have to meet the requirements on the 14 requirements. One of them is accommodation. And this, we can apply the direct reference approach. So in relation to accommodation requirements, we will mention the relevant part in the convention. That I understand. This is a thick blue bill. Many of them are nothing to do with the enabling provision. Where is it? Can you give me the number of the enabling provision? DOJ? It's in Cap 134. We add a new 3A. In the blue bill, it's Clause 66. C619. So the enabling provision is this one. That is bracket 3 capital A under section 134. I understand. No follow-up? Let me read it first. Mr. Tanka Bill. Could you give me a written reply of the 8 points you've just gone over? And I'd like to ask 3 questions on the 3 points. Unions mentioned about people who have committed criminal offenses. Because of the conviction, the criminal record, they cannot work on board. Can you adopt a more lenient approach? Say, for example, those who have been imprisoned for over 3 months before. Because it is quite restrictive if you, say for example, committed a minor offense and you've got a criminal record and you can't work on board a vessel. We know that the Marine Department plays a role. Seafarers can lodge a complaint directly with the Marine Department without going through the ship owner. But can the Marine Department ensure that the procedure is safe? Are there any empowering provisions to empower the Marine Department to take up this role? Well, some people will work on the vessel, and say, for example, a cruise with casinos on board, and they work for less than 3 days. Does it mean that they are not protected because they work for less than 3 days? We will give you a written reply. In relation to pleasure craft, say for example casino vessels, well, in relation to the convention, there is no restriction on 3 days. So if it is an ocean-going vessel, then this applies. And I would defer to Mr. Wong for the other points. Mr. Wong, thank you. I thank Mr. Tang for his 2 questions. First, criminal records. Will it take away for the person's right to work on board a vessel? We have sought legal advice from the DOJ. There are some past cases involving youngsters with criminal records. They would like to work on board of the vessel. The reply from the DOJ was that under Seafarers Ordinance Cap 478, there is a provision stating that if a seafarer has committed these offences, his work will have to be suspended and his qualification revoked. Say, for example, drug trafficking or abscondment. Say, for example, when the vessels call on a port, and the seafarer did not return to the vessel, and later the person arrived, but and resulting in a delay of the vessel and homicide. In these cases, the qualification of seafarer will be revoked and his work will be suspended. And back to what Mr. Tang mentioned, say someone who would like to work as a seafarer and the person committed shop theft. And since it's not mentioned in Cap 478, we may consider allowing that person to be a seafarer. So it's not the case from the communication we had with the DOJ that once a person has got a criminal record, the person cannot work as a seafarer anymore. The second point, in reply to the complaint procedure mentioned by Mr. Tang. When we were making preparations to implement the MLC, we've spent a lot of time to compare the convention with Cap 478. In relation to the complaints mechanism, it's always in place. Say, for example, when a vessel registers, the shipping company will be required to produce a document of a log and a standard agreement. In the log, all the activities will be recorded by the master. And there is also a requirement to inform all seafarers of a complaint procedure. We've already have this in place. The seafarer can make the complaint to the ship owner or the shipping company or the masters, and if they're still not happy with the result, they can get the information about our unit, and we will deal with the complaint directly. This runs in tandem with the procedure, with the complaint procedure under the convention. Previously, there is a set of documents on board the vessel, but now each seafarer has this set of documents. So if they have grievances, they know the channels available to them to make a complaint. I hope that I can answer Mr. Tang's question. So in other words, you will adopt the current practice because you think that it is in order. You will not do anything more. Actually, it is incorporated in the subsidiary legislation. It's a subsidiary legislation to implement the convention. Section 13 is about complaint procedures on board. Mr. Tang Kaiqiang, nothing to follow up? Legal advisor, you have some questions? There are actually 2 points for members and the administration's reference or consideration. First, subsidiary legislation, and number 2, whether the approach of direct reference should be adopted. Subsidiary legislation. Just now the PAS mentioned that if the bill is endorsed, they will draft a series of subsidiary legislation. I'd like to draw their attention to the fact that to the issue whether the existing enabling provision is wide enough to give them power to draft subsidiary legislation. Mr. Lee from the Deputations raised some issues, and the PAS said that she would consider to introduce amendments in the subsidiary legislation. So I'd like to draw their attention to that. And direct reference approach. Section 66 is to add an enabling provision so that at the time of drafting subsidiary legislations, not all requirements will be set out directly. They will be mentioned. The relevant convention will be mentioned in the subsidiary legislation to save having to set out all the requirements in the subleg. So members may consider whether to ask the administration to set out the relevant requirements under the conventions in the legal brief, and if appropriate, attach the details of the provisions of the convention so that members can easily make reference to them. Thank you, legal advisor. Any reply from the administration? PAS? I thank the legal advisor for raising these issues about the empowering provision on the direct reference approach. We have taken reference from other legislations. We think it is appropriate to cover subsidiary legislations. And in relation to setting out the details in the legal brief, yes, we're prepared to do that. Mr. Frankie, the second point, the administration has responded to that. I think it's necessary. Last time a number of members have expressed concern on this issue. Any members who would like to ask questions? If you have other questions, I'd like you to ask them all now so that we can have a discussion with the administration to get some answers from them. And if they can't give an answer now, I hope they will furnish us with written answers. Otherwise, we can start the clause by clause. We still have about half an hour. There aren't too many members here. If that is the case, perhaps we will start the clause by clause in the next meeting.
Mr. Tang Kaiqiang, Mr. Chairman, if clause-by-clause scrutiny is smooth, how much time will it take for us to complete our scrutiny work? It's difficult to say. It depends on how many questions members have on the provisions. We cannot have any forecast at this moment. Any question from the administration? No? Then I suggest that the next meeting be held on the 28th of June at 10:45 a.m., a Friday. Any comment? No? So that will be our next meeting, the 28th. The 28th of June, a.m., 10:45 a.m. I think there's a meeting on MPF. And Chairman, I don't think you'll be available either. We'll discuss this after the meeting because we have to consider the availability of rooms as well. Will it be the 28th? Yes, 28th, all right. We'll consider this again after the meeting. If there's no further comment, thank you very much.